The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The next case is State versus Melvin and Baker, and we will hear from the appellant.
Good afternoon. May it please the court. My name is Sarah Holliday on behalf of defendant appellant Jamel Melvin. The question presented today is whether the Court of Appeals erred in concluding that Mr. Melvin's severance claim was not preserved for appellate review, where the court cited the wrong standard, considered only one of Mr. Melvin's 6 motions for severance, and failed to address Mr. Melvin's alternative allegation of ineffective assistance of counsel. This court's precedent illustrates that there are essentially 2 kinds of motions for severance. The first involves antagonistic defenses, and the second is a situation in which evidence is admitted or excluded to the benefit of one defendant and the prejudice of the other. And this case presents both scenarios. Over repeated objections and motions to sever, Jamel Melvin was tried jointly with his stepson and co-defendant Javial Baker, whose admitted strategy at trial was to exculpate himself by inculpating Mr. Melvin. Throughout trial, Baker elicited some evidence and excluded others in his attempt to guide the jury to the conclusion that Mr. Melvin was guilty. Because Mr. Melvin was prejudiced by the trial court's repeated denials of his motions to sever his case from Mr. Baker, he is entitled to a new trial. Turning first to the question of preservation. The Court of Appeals disposed of Mr. Melvin's severance claim by finding that it had not been adequately preserved, and the court wrongly limited its analysis of this claim to the arguments made by Mr. Melvin's co-defendant at the pretrial hearing. The Court of Appeals relied on the standard for motions of severance of offenses as articulated in State versus Walters. However, the statute, this court's precedent, and common sense all dictate that a different standard applies to motions for severance of defendants. A motion for severance of defendants can be made at any time because, as this case illustrates, new bases for severance and additional evidence for existing bases can arise after the state has rested.
At what point did Mr. Melvin's trial counsel first raise the question of antagonistic defenses?
I believe that was Justice Irvin.
I'm afraid so, yes.
Okay, I'm sorry. I'm just making sure. I'm getting used to this format. So as you know, the first motion for severance comes during the state's evidence, and the words antagonistic defenses are not spoken by counsel, but from the context, we know that up to that point, the evidence had already started to develop in such a way that this is becoming a problem. There's another motion to dismiss at the end of the state's case, another at the end of all the evidence, and both of those are just sort of made and denied. There's no discussion. There's another motion after closing statements in which I believe counsel's exact words were something to the effect of, "I'm objecting based on what Mr. Baker's attorney has just said." And the context is that Mr. Baker's attorney has just said that Mr. Melvin is guilty.
I looked at the transcript references that were cited in the briefs. It looked to me like the first time that your client's counsel raised the issue of antagonistic defenses was in the version of the motion that was made after the final arguments. Is that a correct reading of the transcript?
Well, let me grab my closer notes here. So what he says, what Mr. Melvin's attorney says in the motion after that's made after the jury has returned the verdict is that he wants to put on the record what his previous motions were about. And let me just find the language. I'm sorry, Your Honor. Judge, during the course of the trial, I renewed my objection to the court joining these defendants for trial. I just want to make sure that it's on the record as to why. As you recall, Baker gave a closing and my client, Mr. Melvin, not only had to contest the prosecutor, he also had to contest Mr. Baker. And I think that is a violation of his constitutional rights, both under the North Carolina and the US Constitution. And I think it's clear from that what he's talking about is antagonistic defenses. I think this,
that's the first time, at least as you read the record, that your predecessor at the trial level raised the issue of antagonistic defenses. He may have tried to relate it back to earlier times, but that was the first time he said something himself to that effect.
Well, I mean, I think it's also clear in the previous motion that's made after closing argument. But if you're asking me if the words antagonistic defenses were ever spoken, they were not.
Or the functional equivalent of them. I mean, I don't want to get into magic words here.
Sure. I think it's obviously debatable at what point it becomes clear until we get to the end. And then I think it is indisputable that antagonistic defenses were raised in that last objection.
And your contention is, at what point do you contend that the motion, it was error to deny the motion to sever? You've got multiple ones. Which ones are you talking about?
Mm-hmm. Well, I guess what I would say is, in some sense, it doesn't matter at what point it became clear that these defenses were antagonistic. What matters is this court has always considered the totality of the evidence. This court has always looked back at the trial as a whole. And so, once the objection is clear, once the evidence is clear, I think what we need to look at is what was apparent when that last motion for severance was made. And at that point, I think there were 6 things that the trial court had been alerted to, or that had become obvious as the evidence unfolded. The first being that Baker's attorney argued directly to the jury that Mr. Melvin was guilty. The second being Baker's attorney admitted that his strategy throughout the trial had been to implicate Mr. Melvin. Because Baker didn't testify, Melvin had no way to confront him about these allegations. Fourth, Baker elicited the testimony about the Chicago Smith situation, which otherwise would not have come in and which the state agreed was inadmissible. Fifth, Baker excluded various anonymous tips that were prejudicial to him, and the absence of that information enabled him to argue that all of the evidence pointed to Mr. Melvin. And finally, Baker repeated various evidence elicited by the state in a way that would otherwise have been excluded as cumulative. So I think when we get to that final objection or that final motion for severance, the trial court has been presented with all of that, and that is kind of the bank of evidence that this court needs to consider in deciding whether it was improper to deny that last motion. Just backing up to prejudice. So the Court of Appeals relied on the standard from State versus Walters, which is the standard for the severance of offenses. And it says a motion to sever offenses must be made before trial, or if new grounds arise during trial, they must be made at or before the close of the state's evidence. But the statute contains no such limitation for defendants, which we have to assume is a deliberate choice on the part of the legislature. And indeed, 15A19-1 provides that a motion for severance of defendants is appropriate at any time when it is necessary to a fair determination of guilt or innocence. And this court has routinely considered evidence emerging after the state has rested in deciding claims involving the severance of defendants. For example, in Pickens, the court discusses the testimony of defense witnesses. In Nelson, the court discusses the testimony of the defendants themselves. All of that necessarily comes in after the state has rested, demonstrating that this court has traditionally considered evidence beyond the scope of what the Court of Appeals was willing to consider here. Finally, common sense tells us that the basis of a motion to sever defendants can evolve throughout trial. A defendant can't know whether his co-defendant will testify, what evidence he'll present, whether evidence will be admitted or excluded, and truly whether those defenses will be antagonistic until they are complete. The Court of Appeals lamented that by raising antagonistic defenses on appeal, Mr. Melvin was swapping horses, alleging that that was an argument the trial court never heard, but as recited in the discussion with Justice Ervin, there was a very clear motion to sever at the end of the trial, which put this squarely in front of the trial court. And the trial court had the opportunity to address the conflict, but failed to do so. And in denying the motion, preserved it for appellate review.
With regard to what the Court of Appeals raised about the, quote, serious horse swapping, unquote, the appellate law is replete with the aspect of those that are appealing not being allowed to change horses in order to get a better mount, so the phrase goes. Are you saying that that is completely unpersuasive and inapposite here in light of what the law is under the statute?
Yes, Justice Morgan, I'm saying that the antagonistic defenses issue was squarely presented at the trial level. I believe Judge Ridgway was the trial judge, had every opportunity to address that when the final motion to sever was made. I would also note that to the extent that this case involves the development of evidence in a way that is beneficial to one defendant and antagonistic to the other, that was raised in Mr. Melvin's written pretrial motion to sever, and therefore was preserved when that motion was renewed at the close of the state's evidence.
Is the ability to raise a different defense available to a defendant who is contending that there should be severance, even though substantively there is a different theory being utilized?
I'm sorry, you broke up a little bit during that question. Could you repeat, sir?
Sure. While you're saying on one hand that severance should be available at any time whenever there are inconsistent or antagonistic defenses, is it your position that in terms of the horse swapping aspect, that a defendant who is contending that severance is appropriate reserves the right to be able to change his or her contention as to a theory of lack of guilt at any time?
I just want to make sure that I understand your question. I don't believe that Mr. Melvin was changing his theory as to lack of guilt. Mr. Melvin has maintained his innocence throughout. I do believe that a defendant has to remain free to raise new bases for his motion for severance throughout the trial, because the evidence continues to develop.
To the extent that they may become intertwined at any time, where there is a lack of a distinction between the motion to sever and anything that is substantively being raised in support of the motion to sever. Are you saying that the horse swapping aspect is immune to any type of scrutiny whatsoever because they are intertwined as they are?
I'm saying that, well, first, that to some extent, yes, because of the nature of trying defendants together, the evidence will develop, it will change in ways that weren't foreseen at the beginning, and that is why a defendant is able to renew his motion for severance, present new arguments in favor, in support of it. My position, though, is that the horse swapping completely doesn't apply to this proceeding, because all of these arguments were clearly raised at the trial level. It's not horse swapping for the defendant to respond to evolving evidence at trial. It's only horse swapping if I pluck something out of thin air on appeal that the trial court has never heard, and this court did have that opportunity. Let's see. So earlier I discussed the sort of 6 areas of evidence at trial that should have led the trial court to allow the motion for severance. And I just wanted to note that this court doesn't have to find that any one of those was enough. The evidence can be viewed cumulatively, because this court does assess severance claims in the totality of the evidence. But Baker's entire defense was that Mr. Melvin was guilty, and the only element of the charged offenses that Baker contested was identity.
Well, Ms. Holiday, before we get into this in more detail and looking at a selection of the cases that were cited in the parties' briefs, it looks to me like when we get to the issue of whether Joinder produced such prejudice that it was error to deny a severance motion, it looks to me like the courts really looked at two things. First of all, was your client prohibited from eliciting any evidence that he or she wanted to elicit because of Joinder-related considerations? And secondly, did something come in that wouldn't have come in a separate trial? Those seem to be the two things that are primarily looked at in the case law. Is that essentially what we need to think about at this point?
I think you're describing two sides of one kind of severance, but there is the other, which is antagonistic defenses that are irreconcilable. And so,
well, it looks to me like the case law, first of all, says, are there antagonistic defenses? If there are, we have to, just because there's an antagonistic defense, severance isn't required. That instead we then look to see whether your client was deprived of a fair trial. And at that point of the analysis, it looks to me like what the court does is look at one, was your client prohibited from eliciting any evidence that he or she would like to have elicited? And secondly, did something come in against your client that would not have come in had he been tried by himself? That looks to me like what the court's focused on. Is that a correct reading of the cases, or am I missing something?
I would submit that there are other kinds of prejudice, Your Honor. It's true that obviously that it would be prejudicial to the defendant if the evidence developed, in such a way as to benefit one or the other. But there's also prejudice when the defenses are so antagonistic that the jury will necessarily conclude that they're both false.
And understand that. And I guess my question becomes, how do we make that determination? Broadly writ, what are the criteria that we use to decide whether it was so unfair that your client was essentially deprived of a fair and impartial trial?
Well, I would say that in assessing prejudice in the past, this court has considered several factors. One being whether the defendant had the opportunity to cross-examine the co-defendant who contradicted his defense, for example, in Nelson. And obviously there was no opportunity here for Mr. Melvin to challenge Baker's assertions that he was, in fact, one of the robbers. Second,
he could challenge it by argument, couldn't he?
Well, I think there are a couple of...
That's all that Mr. Baker's counsel did, was he asked certain questions and then based on those questions made an argument to the jury that your client was one of the people that entered the Walnut Creek theater office. I mean, was your client prohibited from responding to that argument in some way?
Well, because counsel is perhaps an avatar for the defendant in these cases. Baker's counsel...
Do the cases treat arguments of counsel as the same as evidence?
Arguments of counsel are not the same as evidence, but this court has recognized that they do impact the jury sometimes in ways that they should not. And what happened in this case was that Baker's attorney essentially got to accuse Mr. Melvin in a way that protected his client from cross-examination. He got to act as Mr. Baker's voice without Mr. Baker actually having to bear the consequences of accusing Mr. Melvin of being involved in this crime. So other factors that this court has considered in the past for prejudice, whether there was overwhelming evidence. For example, in Resor, the defendant was caught leaving the scene, which sort of eliminated any prejudice that may have existed from antagonistic defenses. But in this case, you don't have any forensic evidence tying Mr. Melvin directly to the actual robbery. There are no eyewitnesses that place him either inside the scene or at the dollar store procuring the evidence, the gloves that were allegedly used, or circling the neighborhood as Johnny Bryant testified he was. There's in fact no corroboration for Johnny Bryant's testimony that Mr. Melvin was involved in this crime. And so given the relatively weak circumstantial evidence against Mr. Melvin, his inability to fully confront Mr. Baker, I think there was prejudice in this case, and I think this court's precedent would lead us there. Kind of going back to, excuse me, I don't think there's any real argument that when Mr. Baker's attorney said the defense we've been trying to present to you throughout the questions is that it wasn't Javier Baker, but it was a Johnny Bryant, and it was Jamel Melvin, and it was Lorenzo McNeil. Again, the evidence that I've tried to present to you in my questions have been that the robbery was committed by a Johnny Bryant, by Jamel Melvin, and by Lorenzo McNeil. I don't think there's any real question that that is antagonistic to Mr. Melvin's claim that at the time of the robbery, he was across town babysitting Javier Baker's younger siblings. It's prejudice for the reasons argued. And I would note, Bruton and other cases observe the ways in which limiting instructions, well-intentioned as they may be, can't reasonably hope to sweep away some forms of prejudice. And this is one of those cases. While it's not directly a Bruton analogous situation, I think it is instructive. And to obtain relief, Mr. Melvin only needs to show a reasonable possibility of a different outcome. In other words, that his defense was made less persuasive than it would otherwise have been. And I think clearly having his defense undermined by his stepson and co-defendant did that. Ultimately, the jury had to decide whether to believe Mr. Melvin's alibi, and Baker's assertion that he was actively involved in the robbery made that alibi less persuasive. Joinder also permitted Baker to manipulate the evidence in ways that prevented Mr. Melvin from fully responding to his attacks. And under these circumstances, Joinder was both improper and prejudicial, and Mr. Melvin should be awarded a new trial. If counsel somehow failed to preserve the entirety of the severance claim for appellate review, then he rendered ineffective assistance. And the Court of Appeals erred in failing to address this claim. Indeed, the Court of Appeals analysis suggesting that it would have been easy for counsel to alert the trial court to this problem, and then indicating that the Court of Appeals believes severance would likely have been granted on that basis, indicates that if the court had reached the question, it would have granted relief. If there was insufficient evidence from the cold record to determine the issue, the proper remedy was to dismiss without leave, not to dismiss the severance claim entirely. Are there further questions? If not, I will reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court. My name is Benjamin Zellinger, and I'm from the North Carolina Department of Justice, and I represent the state in this case. On the morning of July 13th, 2015, employees of the Walnut Creek Amphitheater in Wade County went to work. They went to do their jobs, sit at their desks, do laundry, perform various tasks. At 11:30 a.m. that day, their day and their lives changed. Guns were put in their face. They're forced to lay on the ground. They were threatened with death, robbed, and eventually several of them were put in a freezer and forced to kneel. Before the morning was over, $497,000 was stolen. Defendant Mr. Melvin worked there, hatched this plan, and served an active role in it. And eventually $86,000 from the venue was found in a storage facility that not only he had visited, but was found in a suitcase with not just his fingerprints on it, but also his blood and his DNA. The question before this court is whether the defendant in this case ever made a timely motion to sever due to antagonistic defenses, and he did not, and defendant cannot cite to a point when he did. There are 3 points that I'd like to address to this court. First, the Court of Appeals didn't use the wrong standard, and this relates to the timing of defendant Melvin's objections. Second, that a motion for severance based on antagonistic defenses was never made. This has to do with the content of defendant Melvin's objections. And then third, that there were non-antagonistic defenses made in this case. And this case had such overwhelming evidence that the prejudicial effect on the defendant was zero. Starting specifically with the timing and looking at State v. Walters and the Court of Appeals opinion.
Well, before you do that, though, I mean, State v. Walters specifically cites 15A927A, as your colleague points out, or me rather, which refers to severance of offenses. My understanding is that severance of offenses and severance of defendants are two different things. Is that wrong?
And Justice Ervin, I think you're correct in that 15A927 does have different prongs for severance of offenses and severance of defendants.
And doesn't Walters talk about joinder or severance? I mean, you can use them interchangeably, of offenses instead of defendants.
And it is a case about severance of offenses. But what I would point out to this court is that there's no clear line or no clear case law on timing for severing defendants.
What about 15A927C?
2B, I believe.
B, I mean, which seems to me to say if during trial, upon motion of the defendant whose trial is to be severed, or motion of the prosecutor without consent of the defendant whose trial is to be severed, it's found to be necessary to appeal or achieve a fair determination of guilt, there would be severance. Why doesn't that authorize a defendant to make a severance motion at any time up to and including the end of trial?
And Your Honor, I think that that's the question before this court, is when the timing has to occur. And if this court determines that at any point during a trial that the motion for severance can be made based on what happens with the state's case in chief or what happens with the defendant's case in chief, the Court of Appeals opinion still is correct, in that the Court of Appeals opinion states in a footnote on page 12, which is important to note, this rule does not apply to grounds for severance that the defendant discovers after the trial has begun. And so the Court of Appeals got that correct. But it goes on to say, but defendants do not argue that they only became aware of these purported antagonistic defenses during trial. And that brings us back to the swapping horses situation that Justice Morgan spoke of.
What do you make of the argument that Ms. Holliday's predecessor made after the conclusion of the jury arguments?
Sure, and Your Honor, I think there's a distinction that needs to be made there, and I'm sure Ms. Holloway didn't intend this, but the words that she read to you, as you recall, Mr. Wilkinson gave a closing, and my client, Mr. Melvin, only had to contest Mr. Waller, but also had to contest Mr. Wilkinson. That objection, that motion to sever, that came after the verdict. The trial was over at that point. That came in evaluating an aggravating factor. There are 6 times that defendant points to that would constitute severance in this case. And I'd like to go through them with the court because I think they're important, because at no point were any of these raising antagonistic defenses except that one, which occurred after the verdict, where at that point every defendant would seek to sever because the verdict came out clearly for them.
You can't blame them for that.
I'm sorry, Your Honor.
You can't blame them for moving the motion at that point.
I can't, Your Honor, but looking at the first motion for severance, that occurred during the pretrial hearing, and my colleague, Ms. Holliday, pointed out that the defendant made a reference to evidence beneficial for one and bad for another, but it was really a guilt by association argument, and that's different than an antagonistic defense argument. The first line of that motion for severance says that the jury could have insurmountable difficulty in distinguishing the alleged acts of his co-defendant. Again, that's guilt by association. That's a totally different argument. And this all relied around the testimony of a Chicago Smith, who the state didn't call and was never called in a trial. The second action that defendant claims constituted a new motion for severance occurred during the trial when Mr. Melvin's counsel says, "It seems to me that the detective would go in Ms. Baker's statement talking about Mr. Melvin. Wouldn't that be a Bruton violation?" Clearly, that's a different animal than an antagonistic defense. This is a Bruton situation where a statement could have adversely affected him from another co-defendant. The third motion to sever that defendant claims had to do with antagonistic defenses came after the close of the state's evidence. And again, it's important to look at this transcript to see the content of what constitute these motions to avoid a situation where there is horse swapping. And in that one, Ms. Baker, who's one of Mr. Melvin's co-defendants, said, "I'd like to renew my motion to sever," or whatever, "get on the record my objection to joinder, I guess. I mean, all the evidence is association." And then she argued that her client just shocked with the proceeds from this robbery and didn't really have knowledge. Mr. Baker's attorney then responds, "I would renew Mr. Baker's objection to joinder." And then at that point, Mr. Melvin's attorney says, "I'll do the same thing, Judge." At this point in the trial, the state's evidence is closed. There's been no mention of antagonism, no argument of antagonism by this defendant. And so at that point, the fourth action cited by the defendant is a new motion to sever due to antagonism comes at the end of all the evidence. And at that point, Mr. Melvin's trial counsel again didn't articulate an antagonistic defense, stating, "I would renew my motion to object. I would renew my motion to the joinder as well and renew all my previously made motions." Again, there's an absence of defendant's counsel argues in her brief about context, that look at the context of these objections to try to evaluate if there's a motion for antagonism in there. And the case that's cited has to do with a 404B argument, where there's a voir dire about 404B and then an argument about 404B, and then counsel stands up and says, "I'd request an instruction." I would argue that this court can't read into these objections, these motions to sever, that there's antagonistic defenses, because at this point there weren't antagonistic defenses, nor there were any point during this trial. And then the fifth action cited by the defendant is the crux of this preservation argument, and this is the most important one that I would argue to you, and that came after a jury question. So there are the closing arguments, and the jury went out to deliberate. They came back, they asked a question. I believe they wanted to see some testimony. They went out, by my count, they went out 5 times into the courtroom, out of the courtroom, deliberating. They asked a question about clarifying what safe space meant. They asked for a transcript of a co-defendant and a detective's testimony, and asked about admissibility of jailhouse recordings. At this point, things were not going well for Mr. Melvin. Again, there's overwhelming evidence of Mr. Melvin's guilt, and these questions by the jury were strong evidence that things were not going well for Mr. Melvin. And at that point, Mr. Melvin's attorney said, "I did want to revisit a matter and renew my objection to the joinder of this matter based on Mr. Wilkinson's comments and closing arguments." And so at that point, the question before this court is that fair? Is it fair for a defendant to sit there and get to see what the jury is evaluating and get to hear the jury's questions, and then at that point finally put forward a motion to sever due to antagonism? And of course,
let me, before we go any further, Mr. Zellner, just to make sure I'm with you, at least at that point, the jury is in the process of deliberating but has not returned a verdict.
That is correct, Your Honor.
So at least at the time that statement was made, some sort of proceeding was still going on.
That's correct. But if you look at 15A927 C and the case law that surrounds this, the motion to sever due to antagonistic defenses due to new grounds needs to occur immediately after those grounds were raised. And first of all, at RDC, there's no antagonistic grounds in this case. Mr. Melvin and
we can get to that in a second, but I mean, again, the language that I'm looking at that I'm trying to get some help understanding is if during trial, upon motion of the defendant whose trial is to be severed, or motion of the prosecutor, is found necessary to achieve a fair determination of the guilt or innocence of the defendant, that's the time when you can have a severance motion. What case has this immediacy holding that you referred to in your prior argument?
Your Honor, there's a litany of cases, and I want to point you to the correct one. But I would say the litmus test on this, or the test that this court should look at is State v. Nelson. And in that one, the court argued, or this court said that severance should be granted when defenses are so discrepant as to pose an evidentiary contest more between the defendants themselves, and avoid a situation where the state simply stands by. And Your Honor, I'll find that case in a moment for you. And I don't want the court to think that I'm ignoring its question, but I don't have it on the tip of my tongue at this point.
Because I read Nelson again, and I wasn't seeing this requirement that you were urging upon us that the motion be made immediately upon the occurrence of whatever triggered the concern about antagonistic defenses and impermissible prejudice to the defendant.
And I think it comes from Walters, Your Honor. Now that I look back at my notes, and again, that is a case about the joinder or severance of offenses, but there's an absence of case law on the timing of when a severance argument needs to be made in joinder of defendants. And yes, 15A19-1 has that language about it needs to be done in order to have a fair determination of guilt. But what I would say is that in this situation, that never arose. There was never new grounds that constituted antagonism in this case. Mr. Baker and Mr. Melvin were on the same team for the entirety of this trial. The facts of this case involve 3 masked men going into the amphitheater and robbing these individuals. And Mr. Melvin was alleged to be the 4th individual who drove and hatched the plan. And so the state's theory was never that Mr. Melvin was the 3rd person in the amphitheater. That was always Mr. Baker. And that was the belief by everyone, was that it was Mr. Baker. Well, Mr. Baker is sitting there, and then in his closing argument, there's such an overwhelming amount of evidence implicating Mr. Melvin that at that point, Mr. Baker's attorney gets up and makes this argument that Mr. Melvin was there. And that's just a logical argument to argue based on the totality of the circumstances and the evidence that had come out in this case. But there was never a situation, such as in much of the case law that this court has seen, about that would constitute the antagonism. And it's hard to understand, because antagonism here doesn't necessarily mean just opposition or a hostility towards one another. There's, again, a number of cases where this court has found that defendants pointing the finger at each other doesn't constitute the level of antagonism that requires severance. I already mentioned Nelson, that Nelson test, that the defenses have to be so discrepant that the jury just sits there and thinks, well, this doesn't make any sense. Both of these defendants have to be guilty, is really the test. A spectacle where the state sits by and just watches. And defendant points to several cases, such as Boykin. That was a situation where a defendant was confessed to cover up for his brother, who was also charged in the case. And so defendant 1 couldn't explain his confession because he was being tried jointly. Defendant also brings up Pickens, which is a case from 1994 with completely different facts. And I would ask this court to look at Pickens, because that was a situation where there was a shooting after a domestic event where a bullet went through a window and killed a person. And there are 2 defendants arguing that each one of the other one fired the fatal shot through the window. In that case, the state essentially set the stage, and then each defendant put on a huge case, and it was really defendant 1's case versus defendant 2's case. Pickens put on 19 witnesses. Here, Mr. Melvin took the witness stand and testified, and looking at that testimony, didn't really help himself, and was cross-examined.
Mr. Zillinger, just to make sure I'm following the course of your argument, are we now into the issue not of whether the motion was timely, but whether the motion should have been allowed?
Well, Your Honor, I apologize. Maybe I didn't do a good job of explaining this. I would argue to you that if the severance motion needs to be made after the grounds arose, that there never was the antagonism in this case that's found in prior cases from this court.
But it seems to me that point goes to not whether the defendant was still entitled to make a motion, but as to whether the defendant's motion should be allowed.
That is correct, Your Honor. And I think
that's where we are in your argument now.
yes, Your Honor. And so looking at the antagonism, defendant and defendant's brief and in defendant's argument has brought up antagonism several times. And truly, this is an argument just about preservation. But the reason that this court should look at the alleged antagonism is defendant alleges that the judge should have sua sponte jumped in and severed these cases. Defendant also raises that there's an ineffective assistance of counsel claim. And again, there wouldn't be ineffective assistance of counsel in this case because there wasn't antagonism in this case to the level that this court has ruled on.
I'm sorry to interrupt, but I do want to make sure I understand on the preservation, going back a few steps on the preservation argument. Is it the state's contention that the motion to sever at the close of the state's evidence and the motion to sever at the close of all the evidence, that those were either, are you saying they weren't effective motions because the grounds weren't argued at the time? And so they were effective nullities? They didn't preserve anything? Is that your position?
Thank you, Your Honor. I would argue to you that they preserved the motion to sever due to guilt by association, or which is a completely different argument. That was what was preserved by that motion to sever. I think if there's a lack of content for the objection, then the only option left for this court is to look at the prior objections of the defendant. So essentially, there's a pretrial motion for guilt by association to sever due to guilt by association, and then the subsequent motions to sever that had no meaning or had no definition because defendant's counsel didn't supply the grounds. I think those revert back to that initial argument.
And what about the objection where counsel says, I'm moving to sever on the basis of what he just said? Are you saying even there we can't look to the context of what was just said in the transcript to determine the basis for the motion?
I want to make sure I understand the court's question based on what he just said being the opposing counsel's closing argument.
Right.
Yes. So that is the objection I think is the one that makes the most difference in evaluating this. And that one, the issue with that one is that it came after the jury had gone in and out and asked questions at that point. And so that's not an immediate motion to sever due to an antagonistic defense arising. And also I want to point out to the court that the argument of Mr. Baker's attorney, it was 2 sentences in his closing argument in which he argued a lot of the same things that Mr. Melvin argued, that these co-defendants had placed each defendant there, that these co-defendants weren't telling the truth. These defendants throughout the entire trial were riding each other's coattails and arguing the same things. And at closing is the only point where Mr. Baker's lawyer makes this contention, which wasn't objected to by the defendant. And in looking at antagonism, Mr. Melvin took the witness stand. And if truly Mr. Baker and Mr. Melvin had such antagonistic defenses, Mr. Baker never cross-examined Mr. Melvin. He didn't ask Mr. Melvin one question. And so defendant cannot point to situations where there was the kind of antagonism that this court has found to be consistent with the kind that needs to be severed. And look at the United States Supreme Court in Zafiro said that a defendant is not necessarily entitled to severance merely because they would have a better chance of acquittal in separate trials. But in this matter, if you severed each of these defendants and they had individual trials, the trials would look exactly the same as the one that was performed. And so the prejudice to Mr. Melvin is nil or minute because there was no antagonism in this case. Defendant tries to say that Mr. Baker's questions, that Mr. Baker's lawyer's questions somehow constitute a statement. But that's clearly not the case. And along those lines, Mr. Baker's closing argument by his attorney, the jury was instructed that the closing argument is not evidence. And so at some point, looking at all these cases, Barnes and Golphin and Silva, Nelson, all these cases point to the same issue, which is that there wasn't the level of antagonism that existed in this case that warranted severance. And even if there still wasn't antagonism because there was no prejudice to this defendant. This defendant's counsel just argued to you that there was no forensic evidence tying defendant Melvin to the scene. Again, this defendant's fingerprints were found on a suitcase that contained $86,000 from the concert venue. And that money was bound and initialed by the managers at the venue. And when it was found, it still had those initials. And so on that suitcase was this defendant's fingerprints. And if that wasn't enough for the jury, his DNA, his actual blood was on the suitcase. He admitted to going to that storage unit. And then when he testified, Mr. Melvin made an interesting decision to claim that he was just selling marijuana out of that storage facility and claimed he didn't have any access to the product that he was selling, which didn't make a lot of sense. And so there's an overwhelming amount of evidence, and defendant pointed out in her reply brief that the state didn't call it overwhelming evidence in our brief, and that's because I don't want to be hyperbolic, but if we're assigning a legal definition to overwhelming evidence, this is overwhelming evidence. The defendant's fingerprints and blood on the money that was stolen is overwhelming evidence that ties into the scene. And then on top of that, you have his co-defendants testifying against them. And at the end of the day, the jury was left with no conclusion, but that this defendant was responsible and guilty for this. And the last thing I want to do is address some of the defendant's claims about where some of this prejudice may have arisen. And again, these have to do with tips against Mr. Baker, the co-defendant, that were not allowed into evidence because they weren't admissible. Well, in Mr. Melvin's trial on his own, those same tips against Mr. Baker wouldn't be admissible. That would be several levels of hearsay. And it's almost, this trial wasn't a situation where it was Mr. Baker or Mr. Melvin was responsible. They were both responsible. And that's been the state's argument throughout the case and the state's theory throughout the case. And so evidence that made Mr. Baker look better or worse didn't really affect Mr. Melvin at the end of the day, because Mr. Melvin had independent sufficient evidence that proved his guilt. And looking at some of the case law that this court has found, I just want to make sure to distinguish. From 1987, Razor was a decision of this court where this court found that there was no prejudice where the state presents plenary evidence of the defendant's guilt. And that's exactly the situation we have here, where there is significant evidence of the defendant's guilt, such that any antagonism that may have arose didn't exist because there was so much evidence to convict this defendant. And lastly, I'll just close with it. In looking at the timing of these objections, I still would maintain, if you look at 15A927 and look at the prongs that relate to the joinder of defendants, the timeline for it is not clearly enumerated. It's not clearly enumerated in any of the cases that the defendant has cited. In fact, some of the cases that defendant cited, there's an argument made that even at a sentencing hearing, joinder and antagonism could be raised. And truthfully, in that case, the situation was that there was no antagonism. This court found that there wasn't any antagonism. And so in closing, I would just argue this court that because there's not a clear line on when severance and severance due to antagonism needs to be raised, I think this court has to look at this very closely and look at when an argument was actually made by this defendant. Even if this defendant did make an antagonism motion to sever at the close of, or I'm sorry, during the jury question, that wasn't timely because so much time had passed and the jury had been asking questions, and it wasn't when the grounds arose. It was well after, when it became very clear to the defendant that he was minutes away from being convicted. And if the court doesn't have any other questions, I would just respectfully request that for the reasons stated, the authorities cited in the facts of this case, that this court find no error. Thank you.
Thank you, counsel. Rebuttal.
Response to what the state said. First, regarding preservation, there's nothing in the statute that suggests any sort of immediacy requirement when you're dealing with severance of defenses. It simply says whenever it is necessary. And in this case, clearly it was necessary. The trial is not over until judgment is entered, and any motion to sever made before then is deserving of consideration. The argument that guilt by association is different from antagonistic defenses is an interesting one, since one can only be guilty by association with a guilty person. And in this case, to suggest that Mr. Baker, who said Mr. Melvin was guilty, was on the same team as Mr. Melvin, who said that Mr. Melvin was innocent, is frankly absurd. And it's the same sort of antagonistic defense that was considered in Gonzalez, where there was a defendant who said, "I didn't rob anyone, they did," and this court found clearly that was antagonistic and prejudicial. I also wanted to speak a little bit to exactly what happened during Johnny Bryant's testimony. The court is often interested in whether there's any evidentiary contest between the defendants, whether there's any real battle between them. And I would just point out that there were over 40 objections during Mr. Baker's cross of a Johnny Bryant. That is how strongly the two parties fought over the admission of this evidence that Mr. Melvin was led to believe in the pretrial hearing was not coming in. And then Baker decided that that was essential to his strategy of sabotaging Mr. Melvin. Regarding prejudice, I would note that the jury asking a lot of questions does not indicate that it's a slam dunk case for the state. Rather, it indicates that the jury is unsure and they want more time to consider the evidence. And so I don't think it's fair to accuse Mr. Melvin of biding his time and waiting to read the tea leaves of what was going on with the jury. I think what actually happened in this case was that trial counsel did not anticipate the attack that occurred in Mr. Baker's closing argument, and it took him some time to process that and to respond appropriately. And if that failure to respond appropriately is fatal to Mr. Melvin's claim here, I think that's ineffectiveness. I think, let's see. All right, I'm running low on time, so I will say, I did want to emphasize that under Part E of the statute, the trial court has the ability to sever sua sponte at any time. So even if it wasn't clear to Mr. Melvin's attorney that these defenses had become antagonistic, even if he didn't articulate that properly, the court still had the power and the duty to sever these two defendants in order to ensure a fair trial for everyone. The situation that arose at Mr. Melvin's trial is not unlike the process a trial court goes through in evaluating a defendant's competency. If the court holds a pretrial competency hearing and finds that the defendant is capable of proceeding, the inquiry is not forever closed. As the trial unfolds, a defendant who was previously competent can become incompetent, leaving the court no choice but to declare a mistrial. And the same is true of a motion to sever defenses. It's not clear at the outset. If it is not clear at the outset that the defendants have antagonistic defenses or that one will seek to develop the evidence in ways that are harmful to the other, these things can become clear over time. And it is the duty of the trial court to ensure that both defendants receive a fair trial. While a mistrial cannot be declared lightly, it is sometimes necessary. And when the state elects to join co-defendants for trial, it assumes the risk that this sort of situation will occur. Great though the expense of retrial may be, it does not outweigh Mr. Melvin's right to due process. Over repeated objections and motions to sever, Mr. Melvin was tried jointly with a co-defendant who argued to the jury that he was guilty and who manipulated the evidence throughout trial to implicate Mr. Melvin. The Court of Appeals considered only the pretrial motion to sever in finding that this claim had not been preserved for appellate review and remained silent on the 5 later motions for severance, as well as the alternative allegation of ineffective assistance of counsel. Mr. Melvin respectfully requests that the decision of the Court of Appeals be reversed and that he be granted a new trial. In the alternative, Mr. Melvin requests this case be remanded to the Court of Appeals with instructions to reconsider the severance issue under the proper standard and in light of the totality of the evidence, and that the Court of Appeals be instructed to address whether Mr. Melvin's counsel rendered ineffective assistance in failing to fully litigate the severance issue. Thank you.
Thank you, counsel. Thank you, everybody. Madam Clerk.
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.